SJC-13277, Commonwealth versus Roberto, Rosa et al.
Thank you. Attorney Jordan.
Good morning, Chief Justice, Associate Justice, Darcy Jordan on behalf of the Commonwealth. The Commonwealth is asking that the court set aside the judge's motion to vacate. In essence, this motion to vacate was an unlawful restriction on the Commonwealth's power to prosecute. How? Sure. Because it basically put the Commonwealth in the same position had the judge dismissed the case with prejudice. Because when a case is dismissed with prejudice, the Commonwealth's only remedy for going forward on that case would be to either appeal or to ask the judge to reconsider its decision. And here, those are the only two remedies for the Commonwealth in order to prosecute the case as it's entitled to do.
The judge never says it's with prejudice or without prejudice. The judge just says it's dismissed. I know the docket says it's without prejudice, correct?
Yes, and I think...
The judge doesn't say that. So then the defense argues that the judge basically made a conditional or was contemplating whether it's going to be with prejudice or without prejudice. How do you address the fact that she never says with prejudice or without prejudice at the time?
I think the cases from this court, historically, it can be read in to infer that unless it's expressly with prejudice, the inference is without prejudice. And I think part of the Commonwealth's argument here is that this record is very short. It's like 3 pages long. So part of our argument is that there was really no findings of facts that would support a with prejudice finding of the dismissal. So I know we're looking at the Commonwealth is not saying that the dismissal of the charge without prejudice was a lawful error, a lawful order. We're saying that the motion to vacate as the only option for the Commonwealth to proceed with this case, that was the abuse.
So counsel, what would have happened had you proceeded to bring a new complaint or indictment after there was after there was a dismissal and then an order that you file a motion to vacate? What position would you be in?
Just so I understand. So basically, we just followed through with this order and kept going.
What the ordinary course is, you know what we all believe about prejudice and not prejudice, and
absolutely. Well, I think I don't know for certain what the judges would have done when faced with a motion to vacate by the Commonwealth, and this is why I think.
Right, but had you ignored that motion, right, and just said, look, this is without prejudice. We can do whatever we want. We don't need a permission from the trial court. What would have happened to you as the prosecutor?
We would be in this position that we're in right now.
Be in a little bit more of a
You chose to take a 211-3 rather than be held in contempt.
Right.
Yes,
thank you.
yes. So I'm sorry. You know what? I feel like I didn't understand because I feel that's inherent, right? Either as an appellate prosecutor, I know we either follow the order or you appeal.
Right.
Well,
so,
there's still a hybrid point, though, which is the part that I'm a little bit confused by. Let's just say, because I don't know what the exact docket number is, but let's just say it was docket 1000. The judge's order, as I read the hearing transcript, is if you want to bring back docket 1000, you've got to file a motion to vacate this dismissal. But that doesn't seem to infer that you couldn't file an entirely new docket and leave 100 in the wind. And it didn't seem to suggest that.
I respectfully disagree.
Where did it say that in Judge Grant's, I'm reading the decision. It said, if you want to bring back this case, right? Again, docket 1000, you have to file a motion.
Right, and I think the Commonwealth thinks that the problem, and if you will, the separation of powers issue in contravenance to Article 30 is that by doing that, the judge proscribes the only way for which the Commonwealth can go forward and prosecute the case. Because, as we just discussed, if we didn't follow that order by doing what she proscribed, it's to the exclusion of the Commonwealth's other ways of prosecuting a case. So if a case is dismissed with prejudice, the Commonwealth can go forward, either it can appeal that decision of dismissal, it can either file a new complaint, it can indict
But it
or
wasn't
file a
dismissed
motion to
with prejudice.
reconsider. So,
But
I'm
it
sorry.
wasn't dismissed with prejudice.
So I think the Commonwealth understands from the record that it was dismissed without prejudice, yes. But I think the Commonwealth sees the problem being that the judge in this order to vacate restricts its powers and its abilities to prosecute as it sees fit, as prescribed by Article 30. The ability to prosecute.
The 30 violation is the impediment or conditional part of you bringing a new complaint.
That's right, and it's unfettered by judicial approval or appeal. So
To agree, she could have said, all right, I want to put this on for a hearing as to whether this should be dismissed with or without prejudice. I'd like the police officer, the trooper summoned in. She could have done that.
Absolutely, and I think that's part of the Commonwealth's, I think Chief Justice's kind of question about why is this like prejudice? Because by skipping that point, by skipping the hearing, like, is this a speedy trial violation? Let's put it on, let's look at the docket. Is this an egregious prosecutorial misconduct? All of which are proper checks, if you will, in the balance of
Put
power.
it on it because the police brief is about, well, it should be, Rule 36. They've got a little bit of a flavor of a constitutional speedy trial in their brief. It could have been put on for any of that. The judge just can't dismiss it and have the Commonwealth have to come back with a motion to vacate. Exactly,
and I think the Commonwealth takes the perspective that the judge in making this order is kind of short-circuiting, I'll get there, short-circuiting, if you will, the separation of powers. And it seems like her intention was to revive the same complaint, but by doing it in the way she did it, it really infringed upon the Commonwealth's
And you would say that basically you could read it as Justice George may have read it, but you could also read it another way, and it's that reading of another way that puts you at risk as an attorney.
That's correct. And I think by not following through with it, either we had to follow through with the order or seek appellate review. And because the case was dismissed, and that's why we sought a 211-3, because as in the administration of justice, because this does have other further consequences, not to just this case. So in essence, what the judge really did was make herself the gatekeeper to the Commonwealth's ability to prosecute. And I think this kind of stance is kind of like when the judge doesn't accept a nolle pros, right? We understand that there is some kind of checks and balances in the courts, and we understand that this judge was frustrated, which is all acknowledged. And it's also all these kind of ideas and counterbalances are explored in the case law already.
It's the opposite of not accepting a nolle pros.
This is the opposite, right? This is the opposite. So. The Commonwealth just thinks that there's other options and other ways to maybe come to the same conclusion and result that the judge just did not take.
And had one of those other ways been taken, such as having a hearing on why there was such delay, then whether it was a constitutional speedy trial or a Rule 36 speedy trial, we would have had calculations, we would have had the argument, and we could make that assessment, but we can't do that right now.
Correct. I think on the record's so barren that none of those things can be inferred, although I do think it can be inferred that it was dismissed without prejudice.
And she has every right to deal with the case flow management in the session and deal with the amount of times that the case wasn't ready for trial, and maybe even, although grounds weren't there, consider whether it should be dismissed with prejudice. It's just that she's case flow managing in a way that Article 30 doesn't allow.
Absolutely. All those were in her purview and in her discretion. The Commonwealth does not refute that this dismissal was a lawful order. If I could just point to I know my sister in her brief talks about the inherent powers of judicial administration, and I think the powers that we're talking about here are the express powers of the judiciary compared to the executive branch. And my sister talks about the powers, if you will, to administer a court logistically, or even pretrial motions of discovery. And I just want to be clear that the Commonwealth thinks these powers in this case.
Those inherent powers are sometimes cabined by Article 30, right?
Absolutely. But my point is that this is very clearly an abutting of the two powers, or powerful branches here in this case. I see no other questions. Commonwealth rests on its brief. Thank you.
Attorney Horwich.
Good morning, Your Honor, Mr. Clerk. May it please the Court, Esther Horwich representing Roberto Rosa. Faced with the fourth time the Commonwealth has requested a continuance, the judge
Was this a
crafted
dismissal without prejudice or with prejudice?
without prejudice.
Okay.
That's what it appears on the record. The judge,
Then how can a judge make something conditional when the Commonwealth has a constitutional right to bring charges?
because this is the net effect. What would the difference be if the judge says, okay, we're going to continue it for next week for a full hearing?
We'd have a hearing.
Yeah, but in this case, the judge did not indicate that she was denying it. She said, we are going to have a hearing at the Commonwealth scheduling, and all parties can be heard, which is quite different than denying a case and having a prosecutor come up and say, Judge, please reconsider.
When you have a Article 14 issue, do you come to the court and say it was just a little bit of a constitutional violation?
No, Judge, but in this case, we have two constitutional, the judge has a right to control her docket. This is not like most of the cases involving.
Within bounds of Article 30, right?
Exactly, but within.
A lot of different options to control her docket. I understand her frustration, palpable. I really do, and I can understand your client's frustration, and then the trooper, this time he's got an emergency, I get it, but it's either a dismissal without prejudice, bring it again, dismissal with prejudice, and then litigate it, but there's no hybrid.
Well, in this case, Judge, the prosecutor was not prepared to have a hearing on why her witness wasn't there. All the prosecutor knew was that the witness claimed that today there was a family emergency.
Yeah,
And-
but so she could dismiss it.
Right.
She could dismiss it, well, without prejudice, but this judge she's flooded with cases that are not ready. And what she's doing.
Can I follow up with that one point?
Yeah.
Because you were kind enough to put in the record appendix all of the cases that were on for trial that day. And so aside from this case, there were a bunch of cases that were DWOP'd. So is it your contention that in order for the Commonwealth to revive any of those DWOP cases that were all dismissed because they weren't ready, that every case had to be brought back before the judge for a hearing?
No, not at all. This case
What's the difference between this
different.
case?
This case, the Commonwealth had 3 bites of the apple previously. And this case was tying up the court's docket. And the judge wanted to have some control over her docket, which she has the right to
That's why we have
do.
Rule 36, and that's why we have constitutional speedy trial, correct?
Well, that protects the defendant, too.
It does, but
That's the point.
Exactly, but here we have the administration. This is the administration of justice for
and if you,
not
but
just
if,
this
but if you
defendant.
look at those cases that you gave us in the record appendix, a number of those cases were on multiple times for trial as well.
Indeed,
And
but
they were continued.
that
So
may not have been
why
brought-
is this case different?
well, that may not have been brought to the court's attention. This attorney gave the dates, the prior dates, the reasons, the fact that it was the same witness 3 times, and it was a police officer. So a police officer should know the
Does it help the administration
importance.
of justice when the judge makes an order that's illegal and causes the Commonwealth to seek a 211-3, then it goes up to the SJC?
I would suggest that the order is not illegal, Judge, because it wasn't a dismissal with prejudice, which a judge is not allowed to do without a hearing.
Think that the prosecutor could have brought a new complaint and had no problems?
I think the prosecutor could have requested a hearing, in which case the case would be determined whether it would be.
That bumps us right into the Article 30 issue. So if the prosecutor can't go forward and bring a second complaint on this, and it's been dismissed without prejudice, why is this requirement that they come back, not an impingement on that right?
I must respectfully disagree. The case was not dismissed with prejudice.
Without prejudice?
Yes, without prejudice. The prosecutor, if the judge had said, the net effect would have been the same had the judge said, well, we're going to reschedule it for hearing. All the judge did was give the prosecutor the option to pick the day of the hearing. The judge indicated she fully expected to hold a hearing on this matter. The judge indicated that the defendant needed to stay in touch
Counsel,
with the
if she
attorney.
wanted to hold a hearing, couldn't she just have ordered that the case be continued for a hearing on whether it should be dismissed on speedy trial or Rule 36 grounds? Why is this the mechanism that gets you there?
Well, because it sends a more serious message to the prosecution. It it clears off her docket in case you pick a date right now, is the officer available? You don't know. This way, the prosecutor has the option
You're
to...
picking a date not for trial, you're picking a date for the Rule 36 argument at first, right?
Exactly, but the prosecutor may want to bring in the witness who is the
And if
cause
the
of the
witness
delay.
doesn't show then for a Rule 36 hearing, that's very much a problem for the prosecution,
But
right?
this is far more courteous to the prosecutor.
I see. Okay.
Because it gives them...
It's just not semantics, though. She had every right to control the docket. She has every right to be frustrated. And she has every right to consider whether it maybe should be dismissed with prejudice. I don't think it's there or close, but she has every right to have a hearing on that. So she could just put it on for whatever, a week for a hearing on whether it should be, whether it should be dismissed for whatever grounds, constitutional, Rule 36. If you dismiss the case, then you can't have a conditional dismissal under Article 30.
Well, I don't know of any case that comes right out and says that, Judge.
Are
In
there
fact,
cases that say the Commonwealth has a Article 30 right unfettered to bring charges?
those cases all involve issues where the cases were dismissed in the interest of justice. And that's a wonderful concept, but it may not hold the same...
That's not necessarily true. I can't remember the name of the case, but there was a case not that long ago, or 2-3 years ago, about the judge that dismissed the count for use without authority. I think it came to our court. We said, no, you can't do that. This is the Commonwealth's choice as with the separation of powers Article 30 issue. So we've said this repeatedly, that this is their prerogative, the decision to make. I just have one question that I asked Attorney Jordan. I'd like your take on it. Do you take Judge Grant's order when this case was dismissed as precluding the Commonwealth from filing new charges under a different docket number?
I do.
You do?
I do.
And isn't that a problem?
No, I don't think it is, because the Commonwealth is not precluded from prosecuting. The issue is not what the docket number is. The issue is, is the Commonwealth precluded from prosecuting the case? And the Commonwealth at this stage is not precluded from prosecuting the case. That would only occur after another hearing if the judge found egregious conduct. But the prosecutor can certainly prosecute the case. And the issue of what the docket number is totally irrelevant.
Well,
It's an impediment to prosecution, right?
that's the point.
It's not an impediment if the prosecution is not being egregious. It is a continuance if the prosecution, at most. The prosecution is not prohibited from pursuing the prosecution.
But if you go back a couple of dominoes and you say that hearing happens, and let's just say that whatever quantum of proof it is, it doesn't convince Judge Grant, or maybe it convinced another judge, don't you see that that's the problem? Because then that makes it whoever happens to be hearing this particular case and their view of what the Commonwealth's continuances and explanations were beforehand. It doesn't reserve the right that they have under Article 30 separation of powers.
Well, the case is going to be heard by Judge Grant. She reserved it to herself. So because Judge Grant is hearing the case...
Reserve the docket number to herself.
Exactly. Because the judge is hearing the case, the judge is making the determination. Is this an egregious conduct? Is the defendant prejudiced? And if the answer is no, and the case is dismissed without prejudice, or the judge does not allow the motion to vacate, at that point, the Commonwealth has a great issue for appeal. But if the judge finds there is egregious conduct, if the judge finds that the defendant was prejudiced, then the judge can dismiss the case with prejudice.
Are there any cases out there where this kind of impediment was imposed that we've said was okay?
I haven't found any cases that said okay or not okay. So I think this is the first time it's
Are
up.
there any cases that say the Commonwealth's ability to seek charges is conditional?
It says that the Commonwealth has a right to pursue prosecution of charges. You cannot prohibit the Commonwealth from seeking the prosecution of charges.
Right.
And that makes perfect sense, Rule 30. But the judge was not trying to prevent the Commonwealth from prosecuting. The court was trying to prevent the prosecution from coming another time and not being ready. This gave the prosecution the option of picking the date, of having its witnesses all lined up and going forward.
Counsel, what's in it for your client for us to say that what the judge did was okay?
Well, there's a significant amount of prejudice every time a case is brought back for a defendant. Because what happens is you get another charge, and it looks like a new charge. And in this case, it would be 2 years after the old charge.
I understand why your client was prejudiced and not keep having to continue to keep coming in and not having his case, not having to stay in court. But just in terms of what this judge specifically did, how she did it, what's in it for you or your client for us to say, well, that was okay? I mean, there were other ways to do it, so why?
Well, if the judge dismisses it, if the judge gives an out-and-out dismissal and the prosecutor brings it again, it harms the defendant. First of all, in an appointed case, he'd get a new attorney. The attorney would not know the history of the case. The courts would have to redo a new complaint.
Everybody agrees that it was dismissal without prejudice, right?
Right, but the way the system works is if whoever's duty the day the case is brought gets the case.
Right, but it goes back to my earlier point. You gave us all of the other cases that were DWOP that day. If they brought back each and every one of those cases is in the exact same position that your client is in.
Well, some of the cases were DWOP because the witnesses had decided to take Fifth Amendment rights. They didn't look like they were likely to come back.
Okay.
And that makes a lot of difference.
Sure, but the guard for, and this one, I think you already know, I have inside baseball on this one. So I know that the frustration was real, and I can understand where you're coming from, but I'm just trying to figure out, why is this case any different than all of the other cases that you gave us that day that were DWOP, that the Commonwealth could bring back, and it would be restarting all over again, and all of the parade of horribles that you just mentioned? Why would this case be any different, to the Chief's point? What's in it for your client?
Well, it's not so much what's in it for there are two different questions. If you want to know why the case was not, why some of the cases were not brought back, I mean, you'd have to look, I did look into why some of them were, I listened to the whole several hours of that morning. But there are reasons why a case may be DWOP'd and without any anticipation of harm to the defendant. Some of those could be, for example, the parties don't want to proceed and the DA doesn't want to force them. And so in that case, it keeps the case open in case something should change, but it's not likely to go forward. It's not likely that the DA is going to bring it back.
The issue plainly whether or not this is an Article 30 violation, period.
And I suggest that it is not,
Well,
because
isn't that the issue before? It's not whether or not, there was harm to anybody. It's
I'm just
simply whether or not there was a separation of powers violation.
Yeah, it is, and I'm not. I just wanted to. I didn't want to be. I want to respond to the judge's question, so that way that's where I was coming from. But with regard to the Article 30, you've got Article 30 abutting with Article 11, Article 29. The judge has those powers, and sometimes they need to be exercised to keep the case, to keep the flow of the cases. And if the judge has that tool available for situations in which the conduct may be different. I mean, we may not have a situation where a witness is immunized and the case may never come back. We may not have a case where the parties have moved out of state. We may have cases that look like they're not going to go forward, and a dismissal, no one objects to a straight dismissal. But here, defense counsel said, look, I've been ready for trial 4 times, and nothing's happened. And, there are costs. There are costs to the judiciary. There are costs to the defendant.
Haven't you seen cases where defense attorneys have had that exact same scenario, and they say, no, I want my dismissal with prejudice?
Sure, and they aren't entitled to it unless they show egregious conduct.
Right,
or
and so let's argue that.
That's okay, that's fine, Judge. The dismissal wasn't with prejudice because the judge let the district attorney pick a date for a hearing to hear all parties, as the judge said.
But you agree that the prosecution could not start a new complaint?
Right, but they could continue prosecuting this old complaint. And the judge gave that option. And that's what makes this case different from the others, is because the judge did not dismiss it with prejudice, did not make the district attorney file a motion to reconsider, but said, look, I'll hold a hearing whenever it works for you. And that's the difference.
But
that's why it doesn't run afoul of Article 30.
Not.
That was one option available to her. But had she done that, it again sits on the docket. She's no more secure, you know, it's another clutter of the docket. She's no more secure that this witness is going to show up. And I mean, we've got at least three reasons. I'm in South Boston. I'm on vacation, and these reasons are given the day of trial. They're not given before then. So
She could have said, okay, I'm continuing this, and I'm going to dismiss it with prejudice if you don't show up the next time, right?
Right, and the Commonwealth could have, at that point, followed an all pros and completely defeated the judge's attempt to control her docket.
Enter after dismissal?
I don't think it can. I think the case is dismissed. It has to be brought back. So what?
There's been affirmative use of an all pros, which wouldn't be allowed.
Right, so if she gave the case, if she continued the case, it could have been done. It could have thwarted the court's attempt to control her docket.
Right, which we say you can't do in an all pros.
Right. So in summary, I think that this was a very reasoned and balanced approach to controlling the docket. It was a very limited sanction, and it allowed the prosecutor to continue the prosecution of the case. It was not a dismissal with prejudice.
Okay,
Thank you.
very much.